Thank you.
So who's working with you today?
Sandy's supposed to be on, she's not. I, in theory, have all of my stuff.
Is that on?
It's on. Mr. Morton, you already have two people waiting for you. Nicole Young was first, then Mr. Williams. I, of course, have Mr. Williams' case number wrong, and I have no secretary, so that's your warning that today is going to be a day.
Okay, just to confirm normal process, we'll talk to him, then bring it on the record, correct, Your Honor?
Absolutely, thank you.
Okay, thank you.
Mr. Novak. Mr. Novak, I have made you a co-host. If you see any of Mr. Rabbit's tenants, please pull them into a breakout room, discuss the case with them. If you don't have an agreement, come back out here, or if you have an agreement, come back out here, we'll take it on the record. I did receive the dismissal of one of his cases already.
Judge.
Oh, I'm sitting here like these other people aren't sitting here waiting to come in. Thank you, sir.
I'll be back in here with.
Thanks.
You got anything down or no?
Nope, not yet. Thank you. Good morning, ma'am. Nalia?
Hi. Can you
Hi.
hear me?
Yes,
Sorry, I
ma'am. What is
couldn't
your
hear
last
you.
name?
Norris.
Miss Norris, I will fix the name that you have on here.
Okay.
And
Thank you.
I'm going to send you a request to go into a waiting room. There is an attorney here from your landlord. He'll pull you into a room to talk to you about the case, okay?
Okay. That's okay. Perfect.
Thank you.
No problem.
Ms. Macklin, you're going to see an invitation to go into a waiting room. I'm putting you there to meet with the attorney from Holiday West to discuss this case this morning, okay?
Okay,
Thank you.
you're welcome.
To the person on the phone, number that ends in 6609,
Yes,
your name, please?
Sharon Broughton.
Karen Robbins.
Broughton, Broughton.
Ma'am, what type of case do you have this morning?
Mine was an eviction for a gentleman that was staying here, but he left after they served him the papers.
Ma'am,
And then-
ma'am, ma'am, being on
Yes.
the phone is hard to hear you. What time is your case scheduled?
9 o'clock.
9 o'clock, and the last name is Broughton.
Oughton.
Ma'am, do you have your court notice with you by chance?
All I have is the case number, meeting number, stuff like that.
I'm sorry, all you have is what?
The case number they gave me and the meeting number and
What
all
is,
that.
ma'am,
I got that.
what is the case, ma'am?
Yes,
What is the case number?
231407 LT.
Thank you.
You're welcome. Forgive me, I'm kind of old here, sorry.
No, you're okay, but the issue is there a reason why you're not on Zoom? Why you're
I
not
don't
on
know
the camera?
I don't know how to do it. I tried, I just don't know how to do it.
Okay. I
I'm
have not
not
seen
very
Mr.
good at
Cran,
it.
ma'am.
Yes,
I have
Yes.
not seen Mr. Crane yet, but sit tight, okay?
yeah, he said he's working, he can't get on.
Ma'am, no. Your only response is yes, okay? You might not be able to see it, but there are other people waiting for their cases to be called. So just sit
Oh.
tight for a little bit, okay? I'll get back to you momentarily.
All right.
Mr. Morton,
Your Honor, I spoke to Ms. Young, and we have a proposed consent judgment agreement, if I may.
this is 231695 LT. This is Holiday West versus Young. Mr. Morton, I have your appearance. Ms. Young, state your name for the record, please.
Nicole Young.
Yes, Mr. Morton, what is that agreement?
Your Honor, the parties have spoken. We've agreed to enter into proposed consent judgment. Terms are as follows: rents retained of $3,861.20, court costs of $164, for a total of $4,025.20. The payment date / writ date would be May 30th, 2023. Was that she did give me permission to sign her name to the proposed agreement. I did advise of her rights. I did not reference the code section under MCR 4.21, but I did explain to her the 3-day time period and her appeal rights.
Ms. Young, were you able to hear Mr. Morton just now?
Yes,
And it's your agreement that a total of $4,025.20 is due and owing?
correct.
And he explained to you your legal rights regarding your appeal period and your payment date?
Yes,
And you've authorized him to sign your name to the consent judgment?
correct.
Do you have any questions this morning?
No.
Ma'am, what'll happen is Mr. Morton will sign your name to that proposed consent judgment, email it over to the court will sign it, and a copy will be mailed to you at the address we have on record. Anything else this morning, Ms. Young?
No.
Thank you so very much. You have a wonderful day, okay?
Thank you as well.
Bye-bye.
Bye.
Your Honor, I was going to say my plan is to probably bring people out maybe 2 at a time at this moment. So I'll talk to 2 people, come back out, so it doesn't get too far backed up unless you want me to approach it differently.
No, that's fine, considering that you're most of our 9 and 9:15.
Understood, Your Honor. Thank you.
Thank you. Jeffrey Fulton,
Yes.
Mr. Fulton and Ms. Royster Hatter, is your video working?
No.
No, I'm sorry, my phone camera is cracked.
What I will do right now is rename you. I will
Okay.
send you an invitation to go into the breakout room and speak to the attorney for Harbor Club. If you agree with the numbers that he provides to you, he'll bring you back out here. I'll take that agreement on the record. Otherwise, we'll get the matter scheduled for hearing, okay?
Yes, ma'am.
You should see that invitation momentarily to go into his waiting room. Ms. Macklin, what happened? Ms. Macklin, what happened to you, ma'am? Ms.
Hello.
Macklin?
Yes, I'm
Hi.
sorry.
Did you speak to the attorney?
No, I haven't spoke with anyone.
He was here. I mean, he is here. I'm gonna put you back in his waiting room, okay?
Okay, thank you.
Thank you. I'm sending a message to someone who is on unidentified. I'm asking you to start your video and unmute yourself so that may get you properly labeled and matched up with the other side of your case. If you do not respond,
Good morning, Your Honor. I'm unable to use my camera.
what is your name?
Alexis Ford.
Ms. Ford, I will get you relabeled. I'll send you an invitation to go into the breakout room to wait to speak to the attorney representing Harbor Club.
Okay.
If you reach an agreement with him, he'll ask you to return to this main session. I'll take that agreement on the record. If you don't have an agreement, we'll come out, get you scheduled to have a hearing in this matter, okay?
Okay, thank you.
You're welcome. You should see that invitation here momentarily.
Okay, thank you.
You're welcome. Thank you, Mr. Burcroft.
Yes, Judge.
Good morning, Mr. Martin.
Good morning.
How are you, sir?
Something I hit to you, but
You're good. You're
I don't
good.
know how to do all this stuff.
Well,
Bear
what'll
with me.
happen, you bear with me because I'm doing it on my own this morning and I don't typically, I usually have some help. What I am doing is adding your case number
Okay.
and the attorney's name. You're fine. You don't need to do anything. Just sit tight. I have you.
I'm sitting tight.
And what you'll see next is a invitation to go into a waiting room. And it'll say, do you want to join this room? Click yes, or join the room, and you'll go there and it'll be a few other people sitting, waiting to talk to the attorney that represents Harbor Club. Talk to him and then come back out. He'll tell you to come back out here. And then we'll call your case and figure out what we're doing next, okay?
On the computer, right?
Yes, sir.
Okay.
And
So-
if you need any help, there's staff right on the other side of the wall from you, and I'll call downstairs and have somebody come in to help you, okay?
Okay, now what did you tell me to look for?
Oh, I'm sending an invitation. Did a box pop up on the screen asking you to join a breakout meeting room? Oh, he went. I guess the answer is yes. Good morning, Mr. Hitchcock.
Good morning, Judge.
How are you, sir?
I'm pretty good today.
Long time no see.
Yes.
I see that you have a 9:30 case. If you sit tight, if Ms. Boyd appears or someone from that unit, we'll get you matched up into a breakout room.
Okay. I also have two 10 o'clock ones too.
Oh,
Those-
wait.
Those are
Again,
first
it would
time.
help.
I think. Those are probably just going.
Wait, I'm sorry. At 10 o'clock? No,
Yeah.
that's not with me.
Yeah, that's with the mediator, I think,
Don't scare me.
yeah. Okay.
Mr. Mackey?
Yes, how you doing, Your Honor? Good morning,
I
by the
am
way.
super. How are you, sir?
I'm doing well. I can't complain. How about yourself?
What I'm doing right now is I'm adding your case number to how you're identified and the attorney's name. He is here. The attorney for Harbor Club is here. I'm sending you an invitation to go into a breakout room with him. There are some other people ahead of you, but go there, talk to him. If you have an agreement, come out, we'll put it on the record. If you don't have an agreement, we'll hear how we're going to proceed, okay?
Yes, ma'am.
Thank you. This is. Oh. This is 231407 LT. This is Sharon Broughton versus Michael Crane. Ma'am, would you state your name for me, please?
Sharon Broughton.
Ms. Broughton, today is the day and time set for the second hearing in this termination of tenancy matter. The case was scheduled at 9 o'clock. It's now 9:18 by the court's clock. Mr. Crane has failed to appear this morning. The court is looking. There is no one by that name in this court's main session. Hold on one second. There are two unidentified people who just popped into our waiting room. Let me pull them in, get them identified, make sure that it's not, in fact, Mr. Crane. Ma'am, have you had communication with him regarding this case?
Yes,
Is he still in the premises?
no, he's at work.
Has he moved out, ma'am?
Yes, he moved out when they served him the papers.
So, ma'am, how do you wish to proceed this morning?
I just want to make sure that if he tries to like come back or intimidate or anything, because me and my mom were all here, and I just wanted to know that he has to leave if he comes to this house, you know.
Ma'am, he has failed to appear this morning. You are entitled to a judgment of possession. Please submit that to the civil department.
And I don't need anything. I just don't want to come or try to stay at my house or anything.
I'm sorry?
I said, I don't need anything. I just wanted a record that he can't come to my home to stay here.
and ma'am, for that reason, you have to submit a judgment to the civil department that requires him to vacate the premises.
He already did. He left the premises when he served on the papers.
Ma'am, then my question to you is, if he's already gone, but you said you want a record that he can't return, you need to file your request for default judgment. I'm granting it this morning to you, but you need to file the paperwork with the civil department.
Oh, so I gotta come back to the courthouse to do that?
You can do it by email, ma'am.
I'm not real good with
But
the
you
phone.
need to call the civil department for just their email address and that form, okay?
Okay, and judgment. Okay, I'm writing it down. Judgment at the civil department.
Thank you, ma'am. Have a
Okay.
good day.
Thank you, sweetie. Bye-bye.
This is 2314. This is 231749 LT. This is Romulus Towers versus Daryl Finley.
Good morning, Judge. Robert Novak appearing on behalf of the plaintiff.
Mr. Novak, today is the day and time set for the second hearing. A hearing was scheduled at 9 o'clock. It's now 9:21 by the court's clock. Defendant having failed to appear, how would you like to proceed, sir?
We would ask the court for a default judgment for possession. Back rent due and owing through the end of May is $1,308. Cost of $164. Total $1,472. And I have the writ date being the 29th of May.
Default judgment shall enter with the terms just placed on the record. Mr. Novak, if you would have Mr. Rabbit's office submit that as soon as possible, I'll get it signed this morning. Anything else?
Nothing further. Thank you, Judge. Have a good day.
You too. Goodbye, sir. Mr. No. Okay.
Good morning.
Good morning, ma'am. Give me one moment.
Good morning,
please.
ma'am. Give me one moment, please. Okay.
Mr. Coots, if you see
Mr. Coates, if you see,
Sean Norris, please take him into a breakout room. Otherwise, I'll get to you as close to your scheduled time as possible.
That's fine. I didn't see him or I haven't talked with him.
Thank you. To the woman that joined us, your phone number ends in 5941. There's a ceiling fan behind you.
yes, 5041.
What's your name, please, ma'am?
Shante Johnson. CHANTU.
Ms. Johnson.
Mm-hmm.
Thank you. You're represented by Ms. McLemore.
Yes, ma'am.
I have not seen her as of yet this morning, but if you sit tight when she arrives, we'll get you matched up with her, okay?
Okay, so should I put this on mute so you can
Yes,
continue?
please.
Okay,
Yes, thank you.
thank you.
Mr. Taylor, good morning, sir.
Good morning.
Mr. Taylor, I will relabel you. And then you will see an invitation to go into a breakout room to discuss this case with a representative from Harbor Club.
Okay,
When you're done speaking with him, you'll return to this main session and I'll get the case called as soon as possible, sir.
thank you.
You're welcome. Thank you. There is an unidentified person on an iPhone. I am attempting to have you turn your video on so we can get you labeled and where you are supposed to be. May I have your name, please?
Austin Lewis.
Thank you, Mr. Lewis. Mr. Lewis, your case is scheduled at 9:30. I have not seen anyone from Mr. Levine's office as of yet. What I will do in a moment is send you an invitation to go into the breakout room and wait for him. Once a representative is there from that office, they'll speak to you about your case, okay?
Okay, thank you.
You're welcome. Mr. Morton, what case are you ready with, sir?
Your Honor, we have two matters that are ready to proceed at this time. The first one is, was it the GNI Harbor Club versus Byron Williams? That's 231721 LT.
231721 LT. Harbor Club versus Williams. May I have your appearances, please?
For the record, Your Honor, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
Mr. Williams, state your name, sir.
Byron Williams.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Morton, how are we proceeding this morning?
Your Honor, the parties have spoken and they've agreed to enter into proposed consent judgment agreement. Rents retained are $6,336.00. Court costs of $167 for a total of $6,503.00. Was it the payment date would be May 30th, 2023. I did advise him his rights under the statutory reference, specifically explaining to him the 3-day time period that the judgment would not be final for, his right to appeal, and he did give me permission to sign his name to the proposed consent judgment agreement.
Mr. Williams, were you able to hear Mr. Morton just now?
Yes, ma'am.
And Mr. Williams, is your agreement that $6,503 is due and owing in this matter?
Yes, ma'am.
And that you will pay that amount or vacate by May 30th?
That's correct.
Because you appear on Zoom, there is not a signed consent judgment. You authorize Mr. Morton to sign your name to that consent judgment.
Yes, ma'am.
And Mr. Morton explained to you that this judgment is not final and enforceable for 3 days and that your appeal period is 10 days.
Oh, yes, ma'am.
Do you have any questions, Mr. Williams?
No, I don't.
Mr. Morton's office will send that consent judgment electronically to the court. I will sign it and a copy will be mailed to you at the address we have on record. Thank you for your patience this morning. You have a good day, sir.
All right, you too. Thank you.
Thank you. Your second one, Mr. Morton?
Second one, Your Honor, is GNI Harbor Club versus Alicia Royster Hatter and Jeffrey Fulton, which is 23-1723 LT.
231723 LT Harbor Club versus Royster Hatter and I lost it that fast.
Jeffrey Fulton.
Fulton. Your appearances, please.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
State your names, please.
Jeffrey Fulton.
Alicia Royster Hatter.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Morton, how are we proceeding?
Your Honor, the parties have spoken. They've agreed to enter into proposed consent judgment agreement. Was it with rents retained of $3,990, court costs of $189, for a total of $4,179 with a payment / move out date of May 30th. They've advised me that it's their intent to move out before that 30th date. And I advised them that would resolve this case, and this was a possession only action. Further, I did advise them of their rights under the statutory court law, referencing specifically the 3-day time period, that this judgment would not be final until that date. Further, they have the right to the 10-day time period for an appeal, which actually gets pushed out a few more days than that. Also, they gave me permission to sign their name to the proposed consent judgment.
Thank you, Ms. Reister Hatter and Mr. Fulton. Were you able to hear Mr. Morton just now?
Yes.
ma'am.
And it's your agreement, there's a total of $4,179 due and owing,
Yes,
Yes.
ma'am.
and that you will pay this amount or vacate the property by May 30th.
Yes, ma'am.
Yes.
And because you appear on Zoom, there's not a signed consent. Have you both authorized Mr. Morton to sign your name to the consent judgment?
Yes,
Yeah.
ma'am.
And he explained to you that this judgment is not final and enforceable for 3 days and your appeal period is 10 days.
Yes,
Yes.
ma'am.
Do you have any questions?
No, ma'am.
No.
Mr. Morton will submit that proposed consent judgment to the court. The court will sign it and copies will be mailed to you at the address we have on record. Have a good day. You're free to go.
Thank you, ma'am. You as
Use
well.
Thank you. As a housekeeping matter, just so everyone knows, I have no secretary this morning, so it's taking me a little while to get people checked in and labeled. If you give me a moment, there's a gentleman with a gray sweatshirt on. Your name,
Yes,
sir?
ma'am. Rodney Gawne, Gawne.
And Judge, we're here on that one.
I see that case. I have not seen,
We're here for it. I'm here for Murray Duncan, Your Honor. Thomas Machezek.
Good morning, Your Honor.
have you, Ms. Cooper, give me one. Yes,
I'm
ma'am.
sorry. I filed an appearance this morning for Mr. Gawne. That's all I was going to say.
I was gonna ask you if you represent him. Thank you. What I will do is get you both labeled as, let me see, reassigned as co-host. Ms. Cooper, if you would go in, the two of you will go into a breakout room with each other. Do you need your client with you, ma'am?
Yes, I do.
Okay, so let's get you into the miscellaneous room. Mr. Lamond, I am getting you relabeled as a co-host. There are breakout rooms. There's a waiting room and a meeting room for you. There's already a tenant in your waiting room. If you see your other tenants, please take them in and speak with them, bring them back onto the record for any resolution, okay?
Thank you, Your Honor.
Thank you, sir. Mr. Hitchcock, I'm going to move you into a breakout room with Ms. Boyd. Do you need to speak? Do you need Paula from the Housing Commission with you?
Good. Put Paul in there also.
Thank you. It says Duncan, but I'm sending you there. Ms. Boyd? Ms. Boyd? Ma'am, that's just joined us with the red hair and the silver earrings, your name, please?
I'm sorry, I'm Sharnay Bell.
Good morning, Ms. Bell.
Good morning.
Ms. Bell, I've not seen Rashawn Irvin as of yet. But sit tight. I'll get back to you as soon as I can.
Thank you.
Thank you. Jeffrey,
Yes.
I asked you to turn your video on so I can get your last name and get you properly labeled. What's your last name, sir?
Belmore?
Sir, what I'm going to do is get you relabeled. You'll see an invitation to go into a breakout room to discuss this matter with Mr. Landman. If you're able to reach an agreement, well, after you've had a chance to speak to him, he'll have you come back out to this main session. And we'll discuss how we're proceeding, okay?
Okay, thank you.
Thank you.
Judge, would it be possible for me to get put into Mr. Landman's breakout room?
Mr. Koss, let's get you there.
Thank you.
You're welcome. Ms. Cooper has not come back out. Was there a resolution on how we were to proceed this morning, sir?
Yes, Judge, there was, and I think they were trying to figure out how to leave the, she was trying to explain to her client how to leave the breakout room.
Okay. This is 231832 LT. This is Deborah Wooten versus Rodney Gane. May I have your appearances, please?
Yep. Good morning, Your Honor. Thomas Machezik on behalf of Ms. Wooten, who's present here via Zoom to my left, and I'm standing in place of Attorney of Record Murray Duncan for today only. Is that with your permission, Ms. Wooten?
Yes.
Thank you.
Good morning, Your Honor. My name is Rodney. Oh, go ahead, Catherine. I'm sorry.
No, you're okay. You also
Okay.
have to say your name, Mr. Gahn. So my name is Catherine Cooper. I'm attorney for defendant Rodney Gahn, PA 5148.
Thank you, Ms. Cooper. Today is the day and time set for the second hearing in this matter. How are we proceeding this morning?
Judge, Ms. Cooper and I have had an opportunity to discuss things with our clients. We've come to a resolution, if the court would like me to put it on the record.
Absolutely, sir.
Sure. Thank you, Judge. This was a complaint for possession only. We have agreed to do a conditional dismissal, giving Mr. Gani, hopefully I'm saying that correct, till June 9th, 2023 to move out. If he's not moved out on that date, we then are going to convert it, I guess, over to a judgment at that point. That's it.
Those are the terms.
How
yeah.
long will it take you to get this document executed?
We should be able to get it to you before the end of the day, Your Honor.
Yes, Judge. I talked to Mr. Duncan. He should be able to get something over by the end of day.
Thank you.
How would the court like that? Just so I know, would email or should I bring it up to the courthouse? Because we're right down the street.
Dealer's choice. I know where your office is. If you want to bring it over, great. Otherwise, email works perfectly well.
Okay, very well.
Anything else this morning?
Nothing from plaintiff, Judge.
Oh, Your Honor, that's all for us.
Thank you.
Thank you.
That
Thank you, Your
concludes this
Honor.
matter.
Thank you, Mr.
We'll
Gahn.
wait to receive the conditional dismissal. Have a good day.
You too.
Thank you.
You too.
This is 231740 LT. This is Lakeview Mobile Home Court versus Sean Norris.
Robert Coots on behalf of Lakeview Mobile Home Court.
Thank you. Sean Norris or anyone at 405 Loza Lane in Belleville. Mr. Coots, I don't have any unnamed persons in the breakout sessions. There's no one in the virtual waiting room. Defendant having failed to appear. How would you like to proceed, sir?
I have prepared a default judgment I would like to email to the court later this morning. The amounts are $6,664 total, and that includes the $164, the filing fee and the service fee.
Defendant having failed to appear as directed by this court, default judgment shall enter with a total due and owing $6,664. Mr. Coots, if you would kindly email that over, we'll get it signed and get it back to you. Have a good day, sir.
Thank you. You too.
Mr. Morton.
Your Honor, the first case I would like the court to call would be, was it GNI Harbor Club versus, was it Camille Mackey, which is 231711 LT.
Two 231711 LT Harbor Club versus Mackey. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
State your name for me again, sir.
Carmine Mackey.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Morton, how are we proceeding this morning?
Your Honor, the parties have spoken and have agreed to enter into a proposed consent judgment agreement. Was it rents retained are $2,607, court costs of $167, for total of $2,774.00. Was it the payment date would be May 30th, 2023. Was it I did advise Mr. Mackey of his rights, specifically the 3-day time period, his right to appeal, and he did give me permission to sign his name to the proposed consent judgment agreement.
Thank you. Mr. Mackey, were you able to hear Mr. Morton just now?
Yes, Your Honor.
And is your agreement, sir, that a total of $2,774 is due and owing?
Yes, Your Honor.
And you'll pay this amount or vacate the property by May 30th?
Yes, Your Honor. Pay it. But
And Mr. Morton explained to you that this judgment will not be final and enforceable for 3 days.
Yes, Your Honor.
And he explained to you your appeal rights.
Yes, Your Honor.
And because you appear by Zoom, there is not a signed document for the court to enter. Did you authorize Mr. Morton to sign your name to the consent judgment?
Yes, Your Honor.
Do you have any questions, sir?
Well, no, I do not. I'm sorry.
That's okay. Mr. Morton will execute that document, submit it to the court by email. I'll sign it, and then copies will be mailed to you at the address we have on the file, okay?
Yes, ma'am.
Have a good day, sir. Thank you for your patience this morning.
Thank you. You too as well.
Thank you. Mr. Morton.
Sure,
something
the
else?
next party we'd like to call would be Holiday West, and was it Haley Lindsay? It's the first person listed is Marquise Kinsey, but Mr. Kinsey is not here today.
231696 LT Holiday West versus Marquise Kinsley and Haley Lindsay. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of Holiday West.
Ma'am,
And
state your
Haley
name for me,
Lindsay.
please. Thank you, Miss Lindsay. Do you know
Haley
who Mr.
Lindsay.
Kinsey is?
Yes, he's at work, ma'am.
Thank you. Today's the day and time set for the second hearing in this matter. Mr. Morton, how are we proceeding this morning?
Your Honor, the parties have spoken. They've agreed to enter into proposed consent judgment agreement. Rents retained are $1,748.70. Court costs of $198, for a total of $1,946.70. The payment date would be May 30th, 2023. I did advise Ms. Lindsay of her rights, specifically the 3-day time period, the right to appeal. She did give me permission to sign her name to the proposed consent judgment. And finally, I did advise her that Mr. Kinsey would be entered by default, but that would not change the amounts, the time periods. Or the fact that he would have the right to be able to continue to stay as long as the payment is made.
Thank you. Ms. Lindsay, were you able to hear Mr. Morton just now?
Yes, Your Honor.
And ma'am, it's your understanding and agreement that a total of $1,946.70 is due and owing,
Yes, ma'am.
and that you will pay this amount or vacate by May 30th.
Yes, ma'am.
And because you appear on Zoom, there is not a signed consent. You've authorized Mr. Morton to sign your name to the consent judgment in this matter?
Yes, I did.
And Mr. Morton explained to you that this judgment will not be final and enforceable for 3 days, and he further explained to you your appeal rights.
Yes, Your Honor.
Do you have any questions?
No, I do not.
Ms. Lindsay, the judgment will be entered as a consent asked to you and a default asked to Mr. Kinsey for his failure to appear this morning. It will have the same terms. It'll just enter a slightly different way. Mr. Morton will prepare that judgment, submit it to the court. I will sign it, and copies will be mailed to you at the address we have on record, okay?
Okay, thank you.
Have a good day, ma'am.
You too.
Anything else, Mr. Morton?
No, Your Honor, but I think the breakout rooms just broke.
I see that because all these people are popping out. Let's get everybody back in where they belong. Oh, that was fast. I like how that happened. Mr. Taylor, have you spoken to Mr. Morton?
Not at all.
Okay, then let's get you into the breakout room with him. I'm not sure what happened. Are we ready on 231847 LT Romulus Housing versus Beatrice Boyd?
Yes, Your Honor, I believe we are. We met with Mrs. Boyd in the breakout room, and this is a case over her failure to fill out the documents to recertify.
Mr. Hitchcock,
Yes,
your appearance, sir.
oh, excuse me. Steve Hitchcock on behalf of Romulus Housing Commission.
Ms. Boyd, please turn your video on, unmute yourself and state your name for the record.
Beatrice Boyd.
Mr. Hitchcock, you were saying this is a question of recertification.
Yes, Your Honor, and Mrs. Boyd is now at the Housing Commission office, apparently. And it's my understanding she agrees to a judgment to be entered in which she will complete the recertification within 14 days, or we would have right to possession.
And you're presenting that to the court as a consent judgment, Mr. Hitchcock?
Yes, I am, and she advises me that I can sign her name to that consent judgment.
Ms. Boyd, were you able to hear Mr. Hitchcock just now?
Yes.
And ma'am, it's your agreement that you will present yourself to the Housing Commission for recertification within 14 days?
Yes.
You understand that failure to do that will result in you being removed from the property?
Yes.
And because you appear by Zoom, there is not a signed judgment with these terms in the file. Have you authorized Mr. Hitchcock to sign your name to that document?
Yes.
You understand that because the Housing Commission is represented by an attorney, you are not represented. Judgment will not be final and enforceable for 3 days.
Okay.
Do you have any questions, ma'am?
No.
Mr. Hitchcock's office will execute that document, email it over to the court. I will sign it, and then a copy will be mailed to you at the address we have on record. That concludes this matter, Ms. Boyd. Have a good day.
Thank you, Judge.
Thank you, Mr. Hitchcock. This is 231467 LT. This is Rashawn Irvin versus Sharni Bell.
Yes.
Are you laying down during your court hearing, ma'am?
No, yeah, I just got off work at 3:00 this morning. I'm sorry.
That's okay. Today is the day and time set for the second hearing in this matter. I have not seen the plaintiff this morning. Have you seen Rashawn Irvin?
I saw her yesterday, ma'am, before I left for
You have
work.
not seen her this morning. I guess I'll ask the question a little better.
No, I have not seen her this morning, Your Honor.
This case, Rashawn Irvin or anyone from 6315 Higher Street in Romulus, Hayer Street in Romulus. Today is the day and time set for the second hearing in this matter. Matter was scheduled at 9:30. It is now 9:52 by the court's clock. The plaintiff having failed to appear this morning.
Your Honor, is there any way that this situation can be dismissed?
That was the next words out of my mouth. I was just writing the note in the file. The plaintiff having failed to appear this morning, this case is hereby dismissed. There was a note placed in the court file for the civil department to prepare that dismissal. Do you need anything else this morning, ma'am?
No, thank you very much, Your Honor.
Have a good day.
You too. Thank you.
Thank you.
Bye-bye. I apologize for laying down. I
No
didn't get in
worries.
until 3:30
Listen,
this morning.
getting off of work in the middle of the night when it's still dark, I understand, but you're free to go. Have a good day.
Thank you.
Ms. McLemore?
Yes, Your Honor. Good morning.
Good morning. This case was scheduled at 9:30, correct?
Yes, I can't
This
get
is-
my, okay. I can't get my video to come on. Ugh.
This
Okay, I'm
is
sorry.
This is 231935 LT. This is Tetla McConan versus Shantu Johnson.
Yes,
Oh,
Your Honor.
the case that keeps on giving.
Yes.
I'm here. Am I off mute yet?
Yes.
May I have your appearances, please?
Danette McLemore appearing on behalf of the defendant Shantu Johnson.
Thank you.
Shantu
Today's the
Jo-
day and time set for the thank you, ma'am. Second hearing of this matter. This case was scheduled at 9:30. It is now 9:55 by this court's clock. Court is looking for Tedla McConnon or anyone from 10804 Belleville Road in Belleville, Michigan. Case scheduled at 9:30. It's now 9:56 by the court's clock. Ms. McLemore, how would you like to proceed?
I'd like for the case to be dismissed, Your Honor. Your Honor,
Ms. McLemore, would you submit that
I sure will. And I was looking at the ROA this morning and I did see that the plaintiff's attorney called about the date. So this is the second time that they've had their case dismissed for non-appearance. So I don't really know why. But we would request that the case be dismissed and I'd be happy to file the dismissal notice.
Thank you, ma'am. The court will hereby dismiss this case. Defendant's office to submit the dismissal. Ma'am, just so you're clear, we did receive a motion to set aside the default in the other case. I know that did not file an appearance in that case, but that's just more information for you. The court will send notice when that matter is scheduled to Ms. Johnson, and Ms. Johnson might want to follow up with you about it. Anything else, though, as relates to this LT matter?
No, Your Honor.
Thank you
I
very
had a
much. You both
question,
have a
Dawn.
wonderful.
Well, you can call
Probably
me.
not a question for me. It's probably for Ms. McLemore. Trust me.
Yeah, I'll call you when I'll call you this afternoon because I'm going to be in court all day. I'll call you when I get out of court today.
Okay.
All right.
All right. Thank you.
Thank you, Ms. Johnson.
you.
Have a good day.
Thank you. Bye-bye.
Bye-bye.
Good morning, Mr. Robinson.
Judge, I'm on my cell phone now. I'm waiting in Judge Cicerelli's courtroom to call for a 9:30 motion I have, but I wanted to just hop on and let you know that that's what I'm doing. I should be going shortly on this, so.
Okay. I have a whole bunch of other stuff, Mr. Robinson, so take your time with Judge Cicerelli.
I appreciate it. Thanks, Judge.
Thank you. Ms. Johnson, why are you still here? Mr. Levine, I asked you to come out because all your cases are scheduled at 9:30, so I'm prepared to call whatever it is you have, but give me a moment to just grab the files out. This is 231-862 LT. This is Huron Estates versus Chelsea Dingman and Austin Lewis Williams. May I have your appearances, please?
For the record, Your Honor, Daniel Landman, P35797 on behalf of the plaintiff.
State your name for me, please, sir.
You talking to me?
Yes, Mr. Lewis.
Oh, I'm sorry. Austin Lewis.
Thank you. And sir, where is Chelsea Dingman? Do you know?
She's at work at the moment.
Thank you. Mr. Landman, this is the second hearing of this matter. How are we proceeding this morning?
Your Honor, I have spoken with Mr. Lewis Williams, and he has acknowledged that there's currently a rent arrearage of $2,291.50. Costs are $199.20. So the total due is $2,490.70. We would respectfully request that a consent judgment as to Mr. Lewis Williams enter in that amount, and a default issue as to Ms. Dingman with a deadline to pay of May 30th, 2023. I have informed Mr. Lewis Williams that because he is present without counsel, he is entitled to 3 business days in which to file a motion to revoke that consent.
Mr. Lewis, you were able to hear Mr. Landman just now?
Yes, ma'am.
And sir, it's your agreement that a total of $2,490.70 is due and owing in this matter?
Yes, ma'am.
And Mr. Landman explained to you that this judgment will not be final and enforceable for 3 days,
Yes, ma'am.
and that you have 10 days to appeal this matter.
Yes, ma'am.
And because we appear by Zoom, there's not a signed consent judgment. You've authorized Mr. Landman to sign your signature?
Yes.
And sir, you will pay or move by May 30th.
Yes, ma'am.
Do you have any questions this morning?
No, not at all.
Mr. Landman's office will prepare that consent judgment asked to you. It will be marked as a default as to Ms. Deeman. The terms will be the same. He will email that to the court. I will sign it, and then copies will be mailed to you at the address we have on record, okay?
Yes, ma'am.
Have a good day, sir.
You too. Thank you.
Thank you. Mr. Landman, we received the dismissal in 231860 LT that was Huron Estates versus Tammy Ball. I signed that document already and is already on its way downstairs. This is 231859 LT. This is Huron Estates versus Jeffrey Belmore. May I have your appearances, please?
Yes, Your Honor, Daniel Landman appearing on behalf of the plaintiff.
State your name for me, Mr. Belmore.
Jeffrey Belmore.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Landman, how are we proceeding?
Your Honor, I did have a chance to speak with Mr. Belmore in a breakout room. He has acknowledged a current rent arrearage of $2,155.11, costs of $164.60, for a total of $2,319.71. We respectfully requested a consent judgment issue in that amount, with an order of eviction to issue after May 30th if that amount is not paid in full. Your Honor, as Mr. Belmore is unrepresented by counsel, I did review with him his 3-day right to rescind, which he could pursue by filing the appropriate motion with the court.
Thank you. Mr. Belmore, you were able to hear Mr. Landman just now?
Yes, I was.
And sir, it's your agreement and understanding there's a total of $2,319.71 due and owing?
Yes, it is.
And sir, you will pay this amount or vacate the property by May 30th, 2023.
Correct.
And because you appear by Zoom, sir, there is not a signed consent judgment in the file. Have you authorized Mr. Landman to sign your name to that consent judgment?
Yes.
And sir, you understand that because you are not represented by an attorney, that judgment will not be final and enforceable for 3 days.
Correct.
And you also have 10 days to appeal this decision of the court.
10 days.
Yes, sir.
Okay.
Do you have any questions, Mr. Belmore?
No, ma'am.
Mr. Landman's office will prepare a consent judgment with those terms, email it to the court. The court will sign it and a copy will be mailed to you at the address we have on file. Thank you for your patience, Mr. Belmore. You have a good day.
Thank you, you as well.
Thank you. Mr. Landman, the court did receive the dismissal in 231856 LT this morning. That's Huron Estates versus Lanika Jones. That document has been signed and is already on its way downstairs for the civil department to enter and mail out to the parties. The last case that I'm showing for you is 231868 LT. That's Huron Estates versus Kevin McFall and Christine Millican.
For the record, Daniel Landman for the plaintiff. I do not believe that Ms. Milliken is present, and Mr. McFall, Your Honor, is deceased.
Oh.
As such, we would move to dismiss without prejudice as to Mr. McFall.
Thank you. This matter was scheduled at 9:30. It is now 10:04 by the court's clock. The defendant number 2, Christine Millican, having failed to appear, default judgment shall enter as to her. Defendant 1 is dismissed as deceased. Mr. Landman, the amount of rent due owing in this matter?
Is currently $4,376.58, with costs of $199.20, Your Honor, for a total of $4,575.78.
Thank you, Mr. Landman. If you would submit that to the Civil Department for entry, it would be greatly appreciated.
Your Honor, we will do that. Have a wonderful afternoon.
Wait. 231863 LT Huron Estates versus Solinger and Klaus. The court last night saw that there was a consent judgment received, but I haven't seen it unless that's what Sandy has in her hand right now.
It was.
But I know it's here.
It was emailed over, yes.
It's here, it's marked as here. It just hasn't reached the file yet. Thank you, Mr. Landman.
Thank you. Again, have a wonderful afternoon, Your Honor.
You too, thank you. Were you supposed to be on this morning to help? Oh my God. Yeah. I forgot about it. Yeah. Oh my God. It's been fun. Mr. Koss, anything else, sir?
No, ma'am.
You're just hanging out? That's fine.
No. Have a wonderful afternoon.
Take care, sir. Well, 9 o'clock became 9:30, 9:30 became 10 o'clock, and I was like, oh, it's not bad. Ian is the bulk of it. That's okay. Did you call the interpreter?
Not yet.
Call the interpreter off.
Can you tell her not to
Tell
come?
her not to come.
Okay, I told him I said, I'm like, oh.
It is what it is. He's an older gentleman. I remember Mr. Robinson's already come on. He's tied up in 18. So this is good. All I have is Mr. Morton. She's not here. They're not here until 11. So hopefully that gives you time to waive her
Yeah,
off.
that's what I'm hoping. I can
Okay,
help.
thanks.
I wanna make sure- oh, I need to file because that's the only place I have the DEFCAN number. It's, I think- It's in there. What did I put it in there? Do you think they'll still charge us?
I hope not.
'Cause I told them, I said, you
524.
guys may be liable for the charges because we do have an interpreter coming. So I just kind of said that to him, not knowing if they would or not.
I know, and I saw how much it was. So thank you. If you put it over to next week, I don't care what time. Well, maybe back at 11.
At 11 next week?
Yep.
Okay, thank you.
This is 231715 LT. This is Harbor Club versus Norris. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
Ma'am, state your name for me again, please.
Nayla Norris.
Thank you. Today is the day and time set for the second hearing in this matter. The parties have had an opportunity to speak. Mr. Morton, how are we proceeding this morning?
Your Honor, the parties have spoken and have agreed to enter into proposed consent judgment agreement. Rents retained are $4,431, core costs of $167 for a total of $4,598.00. The payment date would be May 30th, 2023, which Ms. Norris feels comfortable that she will be able to pay. I did advise of her rights, specifically in regards to the 3-day time period, the right to appeal, and then she did give me permission to sign her name to the proposed consent judgment.
Thank you. Ms. Morris, you were able to hear Mr. Morton just now?
Yes,
And ma'am, it's your understanding and agreement that there is a total of $4,598 due and owing,
correct,
and that you have 10 days to pay this amount or vacate the property.
correct.
And because you appear by Zoom, there is not a signed judgment in the file. Have you authorized Mr. Morton to sign your name to that judgment?
Yes,
And Mr. Morton explained to you that this judgment will not be final and enforceable for 3 days, and you have 10 days to appeal any decision.
yes.
Do you have any questions, Ms. Morris?
No, I do not.
Thank you. Mr. Morton's office will prepare that document submitted to the court by email. I will sign it and copies will be mailed to you at the address we have on file. Thank you for your patience. You have a wonderful day.
Thank you, you as well.
Thank you. This is 231719 LT. This is Harbor Club versus Jermaine Taylor. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
State your name for me, please, Mr. Taylor.
Jermaine Taylor.
Thank you. Today is the day and time set for the second hearing in this matter. The parties have had an opportunity to speak. Mr. Morton, how are we proceeding?
Your Honor, the parties have agreed to enter into a proposed consent judgment agreement. Rents retained are was it $2,392.00. Court costs of $167 for a total of $2,559.00. I did advise Mr. Taylor of his rights under MCR 4.201, which, as I explained to him, the 3-day time period, which means the judgment would not be final for 3 business days. Second, the appeal time period. And then finally, he did give me permission to sign his name to the proposed consent judgment agreement.
Mr. Taylor, were you able to hear Mr. Morton just now?
Yes, ma'am.
And sir, it's your understanding and agreement that a total of $2,559 is due and owing,
Yes,
and that you will pay this amount or vacate the property by May 30th.
correct.
And he also explained to you that because you are unrepresented, the judgment will not be final and enforceable for 3 days.
Yes,
And sir, because you appear by Zoom, there is not a signed judgment. Have you authorized Mr. Morton to sign your name to that consent judgment?
yes,
Do you have any questions this morning, Mr. Taylor?
not at all.
Thank you, sir. Mr. Morton's office will prepare that consent judgment, sign it, email it to the court. I will sign it, and a copy will be mailed to you at the address we have on file, sir. You have a wonderful day. Thank you for your patience.
You too. Take care. Thank you.
Mr. Morton, I see you have 2 more. You have 2 more.
Okay, I'll speak in your honor. Was it? There's 2 parties that I've spoken to. They're in the breakout rooms. Those ones do not appear like they're likely going to resolve. I was going to speak to them one more time to see where we're at. But I do see that we have Melissa Ziegler, which is a motion hearing, your honor, for entry of a.
But let me zip through some other. What happened to Ms. Macklin? She was here, she left. Mr. Morton, let me call your other cases so we can clear this up. 2316710T. This is Rawsonville Woods versus Devon Holmes. This matter was scheduled at 9 o'clock. It is now 10:12 by the court's clock. There are no unidentified persons in the court's breakout sessions. There's nobody in the court's virtual waiting room, and there's no one downstairs claiming to be present on this case. Is there anyone? This can't be right. I'm sorry, Mr. Morton, I see a Detroit address on this file, which.
You're on, it's because there's 2 addresses. There was an offsite address listed in the Detroit address, and there was a site address listed at 30 Carriage Lane, Site 30, Belleville, Michigan. So there's 2 addresses.
I just saw that on the notice. In any event, this matter was scheduled for 9 o'clock. It's now 10:13. The defendants failed to appear. Mr. Morton, how would you like to proceed?
Your Honor, at this time, we'd ask a default judgment for possession be entered. Rents retained are $2,151.32. Court costs of $164 for a total of $2,315.32.
Defendant having failed to appear, the court will enter the default judgment with a total due of $2,315.32. Plaintiff's office to submit that default judgment for entry. 2316910T Holiday West versus Sharice Macklin. Mr. Morton, the court notes your appearance for the record. Ms. Macklin was here. Did you speak to her this morning?
I do not have a record of speaking to her, Your Honor. I've spoken to quite a few people. I try to take notes on the people I've spoken to. I do not have a record of speaking to Ms. Macklin.
Thank you. Mr. Morton, she was here. I admitted her multiple times and put her in your breakout room. She has not stayed for this case to be called. How would you like to proceed, sir?
Your Honor, based on the fact that Ms. Macklin is not present, we would ask a default judgment for possession be entered. Rents retained are $2,335.24. Court costs of $164 for $2,499.24.
Defendant having failed to appear as directed by this court, default judgment will enter with a total due of $2,499.24. Plaintiff's office to submit that judgment for entry. This is 2316980T. This is Holiday West versus Peter and Elizabeth Lorenzi. Or anyone at 556 Delaware in Belleville.
Your Honor, we would move to dismiss this matter without prejudice. The court should have received the dismissal, but I think it was sent late yesterday.
Thank you. I have not seen that dismissal yet, Mr. Morton, but I will follow up with Sandy. The file will go back downstairs with the indication that plaintiff has dismissed. This is 231710 LT. This is Harbor Club versus Christopher Leib, Leib, or anyone at 48501 South Service Drive in Belleville. Go ahead, Ms. Frania. Look, I see you. Mr. Morton, this case was scheduled at 9 o'clock. It is now 10:15 by the court's clock. I have no response from the tenant or anyone at that address. How would you like to proceed, sir?
Your Honor, at this time, we'd ask a default judgment for possession be entered. Rents retained are $4,915.00. Court costs of $167 for a total of $5,082.00.
Thank you, sir. Defendant having failed to appear as directed by this court, default judgment shall enter with a total due to plaintiff of $5,082. Plaintiff's office to submit that judgment for entry. This is 231812 LT. This is Holiday Woods versus Tamika Young. This matter was scheduled at 9 o'clock. It's now 10:16 by the court's clock. Is there anyone here from 20203 Magnolia Place in Belleville? Mr. Morton, the court notes your appearance for the record. There's no one responding to the court call. There are no unidentified persons in this session. How would you like to proceed, sir?
Your Honor, at this time, we'd ask a default judgment for possession be entered. Rents retained are $947.75. Court costs of $164 for a total of $1,111.75.
Defendant having failed to appear as directed by this court, default judgment shall enter in this matter with a total due to plaintiff of $1,111.75. Plaintiff's office to submit that judgment for entry. This is 231683 LT. This is Holiday West versus Robert Boggs. Mr. Morton, the court notes your appearance for the record. This matter was scheduled at 9:15. It is now 10:17 by this court's clock. Is there anyone here from 244 New Mexico in Belleville? There are no unidentified persons in this court's main session or any of the breakout rooms. The defendant having failed to appear this morning, Mr. Morton, how would you like to proceed?
At this time, we'd ask a default judgment for possession be entered. Rents retained are $1,895.75. Court costs of $164 for a total of $2,059.75.
Defendant having failed to appear as directed by this court, default judgment shall enter in this matter with a total due to the plaintiff of $2,059.75. Plaintiff's office to submit that judgment for entry. This is 231718 LT. This is Harbor Club versus Boise Smith or anyone at 49021 South I-94 Service Drive. This matter was scheduled at 9:15. It's now 10:18 by the court's clock. There are no unidentified persons in this court session. No one responding to the call. Defendant having failed to appear. Mr. Morton, how would you like to proceed in this matter?
Your Honor, at this time, we'd ask a default judgment for possession be entered. Rents retained are $1,215. Court costs of $167 for a total of $1,382.00. This is an action for non-payment of rent by the landlord. It's possession only.
Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with total due to the plaintiff $1,382. Plaintiff's office will submit that judgment for entry. This is 231727 LT. This is Harbor Club versus Trayvon Hagrove or anyone at 48571 South I-94 Service Drive. No one responding to the call. There being no unidentified persons in this court session. Defendant having failed to appear as directed by this court, case scheduled at 9:15 is 10:19 by the court's clock. Mr. Morton, how would you like to proceed?
You're at this time, based on the defendant's failed to appear, we would ask a default judgment for possession be entered. Rents retained are $2,459.54. Court costs of $189 for a total of $2,648.54. Again, this is a non-payment rent for possession only.
Thank you. Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with a total due of $2,648.54. Plaintiff's office will submit that judgment for entry. This is 231732 LT. This is Harbor Club versus Janie Yonkin or anyone at, I'm sorry, and Brian Hassel or anyone at 48870 Denton Road. This matter was scheduled at 9:15. It is now 10:20 by the court's clock. There are no unidentified persons in this court session. Defendants having failed to appear this morning, Mr. Morton, how would you like to proceed?
Your Honor, based on the defendant's failed to appear, we're asking a default judgment for possession be entered. Rents retained are $2,569. Court costs of $189 for a total of $2,758.00. Again, this is an action for non-payment of rent by the landlord for possession only.
Thank you, sir. Defendants having failed to appear, default judgment shall enter with a total due to the plaintiff of $2,758. Yep. The interpreters, is this the one that I pulled to the side and put, okay. Okay, Ms. Ford. This is 231707 LT. This is Harbor Club versus Alexis Ford. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
Yes.
Ma'am, turn your video on, state your name for the record.
I'm not able to video chat right now. My name is Alexis Ford.
Today is the day and time set for the second hearing in this matter. Mr. Morton, how are we proceeding?
Your Honor, the parties did speak. We were unable to come to a resolution. Was it at the time of speaking? Ms. Ford was asking for a reduction, which we would not agree to at that time. Again, so my plan was to speak to her again, but we were unable to come to a resolution.
Mr. Morton, what is the rent to retain possession in this matter?
At this time, Your Honor, we're seeking $3,896.00.
Ms. Ford?
Yes.
I'm sorry, what's the reason why you're not turning your video on for the court?
I'm actually not able to video chat. My phone isn't working properly.
Mr. Morton has placed on the record that there's $3,896 in rent due and owing, ma'am. Are you
Yes.
disputing that this is the rent due and owing?
No, I'm not disputing that. I was actually accepted by DHS for March's rent, but my landlord didn't accept it because it wasn't a check or a money order. So I was asking, could it be removed from my ledger because there wasn't a legit reason as to why it wasn't accepted.
I'm sorry.
I was requesting that March's, I'm sorry.
No, I'm saying it back to you because maybe I'm not understanding. Did you say that DHS was going to pay March's rent and the
Yes.
landlord refused to accept it?
Yes.
Okay. And you wanted it removed because?
Because there was no legitimate reason as to why it wasn't accepted. The attendant at the office had told me that it was only because there wasn't a check or a money order. So I wasn't sure why it was unaccepted because we're also allowed to pay our things online too. So I'm not understanding why they didn't accept the payment.
Mr. Morton, do you have any information about that?
I know the standard, and as I mentioned to Ms. Ford, I haven't dug into the issue completely, but I do know that it's standard that they do not accept electronic payments when cases are in active legal based off the fact that those payments routinely will, to be quite honest, bounce or not go through. So they do ask for, written checks and or money orders from tenants specifically, because the access to the online portal will get turned off because it's too often that people will submit payments and then there'll be issues about those going through. So they require that all the payments be submitted in a check form or in certified money orders. And I know that I've had countless clients receive money orders, not money orders, but checks from, assistance organizations.
Ms. Ford, this court does not, and courts typically do not get involved in how tenants make payments to landlords. The matter before this court this morning is the amount of rent due and owing. This is a non-payment of rent case. Mr. Morton, as an officer of the court, has placed on the record that there's $3,896 due and owing. Do you dispute that that is the amount of rent due and owing?
No.
Ma'am, inasmuch as you admit the amount of rent due and owing placed on the record by the attorney is accurate, there is not a tribal issue of fact, and the plaintiff is entitled to entry of a judgment with that amount, $3,896, and then Mr. Morton, your court cost.
Muted myself, Your Honor. Court cost of $167.00.
Thank you. Ms. Ford, again, because you admit and acknowledge that their rent claim due and owing is accurate, plaintiff is entitled to entry of judgment after hearing with that dollar amount on it, $3,896 and $196 in court costs. Mr. Morton's office will submit that judgment for entry. If there is still money that DHS will pay, this might be a good time to have a different kind of conversation with the office about having that payment submitted in a form that Harbor Club would accept. Anything else this morning, Ms. Ford?
No, that's it, Your Honor.
Thank you, ma'am. Have a good day.
You too.
Let's get Mr. Martin out. I heard you about Mr. Ziegler. Sorry about Ms. Ziegler, and I see her here, but there's someone else from an earlier case. I'll get Mr. Martin's case called. Mr. Robinson, Ms. Froniuk was here. She was going into an in-person hearing. Let me finish clearing up the earlier dockets. Are you ready?
Judge Cicerelli has an elementary school class in her courtrooms.
Okay, Mr. Robinson, and then Mr. Robinson, just so you know, the other thing, the court received communication this morning that Mr. Roberts will be unavailable. You and I can talk, or not you and I, you and Sandy can talk about that offline. So we've adjourned this matter over to May the 24th at 11:30. If that's not a good time for you, again, you can talk to Sandy about it, but we have already waived off the ASL interpreter.
Okay. May 24th. I'm sorry, Judge, what time?
11:30.
Okay.
And
Okay,
since
great.
Ms., I'm sorry, let me do Mr. Martin real quick, and then I'll call the Sunbeam case. This is 23171-2LT. This is Harbor Club versus Morton.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
Mr. Martin, state your name for me, please, sir.
Scott Martin.
Same last name, but no relation. Mr. Morton, you've spoken to Mr. Martin. How are we proceeding this morning?
Your Honor, the parties have spoken. We were unable to come to a resolution at this point. I know that Mr. Martin I spoke, was that he proposed an offer that we were going to discuss, but at this time, we have not come to a resolution. Mr. Martin had multiple issues that he was raising, as well as we were unable to, he did not agree with the balance that was due and owing as well.
Mr. Morton, what is the rent due and owing in this matter?
Your Honor, at this time, we have listed as the amount due and owing, on his account as, $500 in court costs of $167 for a total of $667.
And because he did have an
Mr.
accident.
I'm sorry, Mr. Robinson, do you need to speak to Ms. Froniuk?
But there's also.
Judge, as I was saying, I'm still waiting for Judge Cicerelli to call my case. She has an elementary school in there and she's explaining every single minute matter.
I understand that, but because you're unmuted, you're interrupting my hearing. And if, no, you're fine. But if you wanted to speak to each other, I will put you into a breakout room and see if you can make progress while you're waiting for the elementary school.
I think I'm up next, Judge. So I'm going to leave.
Oh, go ahead.
Okay, thanks.
Okay. Mr. Martin, Mr. Morton has placed on the record that the rent that is outstanding is $500, and then there's $167 in court costs. What's your dispute with that statement, sir?
Hang on, wait a minute. That was there. I don't owe rent. Rent zero. I've always paid the rent. I've never missed rent. What he was trying to say was those are late fee costs. Because their policy is you got to the third and the rent got paid, but 2 times I didn't get the rent paid until the 5th because I had complications with the banks. They had a credit card fraud we discovered. So I had to go through a dispute and it's a 7 to 10 day process. But luckily, they went through a little bit quicker, and instead of waiting maybe another whole week, I was able to get rent there by the 5th. It's just 2 days past charging you for the late fee. That's where 2 of them came from. So the third one is something that they're gonna have to go over with their staff, because I've already talked to Lindsay, and she found the first mess up right from the start, which is when we redid the lease in August. They have this app called the Habitat app that you pay your rent from, and they didn't have it correct on my first rent. Was supposed to be $1,007, but I think they only charged me like $986, so I paid the $986. And that's when they first charged me my late fee. So that was right from the go. So there's 3 late charges right there. 1, not my fault, that was their fault. And 2 was the bank's fault, and I couldn't do anything about it. So I had to wait for the dispute to go through, which I got the
Mr.
rent
Morton,
there.
I'm sorry, Mr. Martin,
Uh-huh.
I'm interrupting you and stopping you for 1 second.
Okay.
Because if there's a disagreement, what we need to do is swear witnesses in and take testimony. Mr. Morton, do you have your witness available?
Yes, Your Honor, I can have, was it my client, was it Miss Burgess log in just a few minutes?
Okay, then Mr. Martin, what we will do is I have 2 more cases that I need to call, and then we'll be calling the case and taking testimony. There was a question, in reviewing the file, Mr. Martin, I did note that your rent's $1,007 a month, but there was only $400 due and owing, so I knew that there was something afoot. We'll see if we can get to the bottom of it, but continue to sit tight there in the Zoom room. The other 2 matters should be relatively quick to address. But you're fine where you are. You don't need to touch anything. Just sit there. I'll recall the case shortly, okay?
Do you want me to unmute it?
If you can be quiet, absolutely.
No, I mean, okay, I didn't say that. Do you want me to mute it?
If you want to, but there's not that many more cases, but you're fine. You could just, if you sit there and you're
Yeah,
not.
I don't have to say nothing. It's fine.
Thank you. This is 224577 LT. This is Country Meadows versus Melissa Ziegler and Theodore Watson. May I have your appearances, please?
Melissa Ziegler.
Your Honor, for the record, Attorney Ian Morton, Appellate Law on behalf of Country Meadows.
Thank you. Today is the day and time set for hearing on the plaintiff's motion for issuance of an order of eviction. Mr. Morton, did I understand you to say that you had not had the opportunity to speak to Ms. Ziegler?
That is correct, Your Honor. This is also an account that no payments have been made since last year, and this is a owned home in which the home is still sitting on the lot.
Ms. Ziegler, the court shows a default judgment entered in this matter on January 5th, 2023 by default. The plaintiff's office submitted an application for an order of eviction on April 26th, wherein they cited that $0 had been paid on the judgment in this matter. The court scheduled the matter for hearing as more than 56 days had passed since entry of the judgment. Ma'am?
Yes, Theodore took care of all that. He's no longer here, so I mean.
What do you mean he took care of it?
He took care of all the bills. We're no longer together, so I'm here alone now.
I'm sorry, Ms. Ziegler, I'm not understanding. A default judgment entered when you failed to appear for court back in January. Did you receive a copy of that?
I didn't. I'm sorry. Can you say that again?
A default judgment entered in this case back on January 5th when you failed to appear for a court hearing. Did you receive a copy of the judgment that the court's staff mailed to you on January 5th?
No, ma'am. I did go to a hearing because we applied at oh, I forgot the name of it. It was, we did apply for help. And then I got We got 30 days for that, so I'm not sure.
Ma'am,
Yes,
there was a hearing back on October 12, 2022. You indicated to the court staff that you had made an application for rental assistance, which
Yes.
caused the court to stay the matter.
yep, that's what I'm talking about.
Okay, the court did in fact stay the matter, and then plaintiff submitted a request to lift the stay, and the court scheduled the matter for hearing on January 3rd. Notice would have been sent to you at the same address that notice about today's hearing was sent to. On January 3rd, this court called the case at 1:59 PM and you had not appeared. Neither you nor Mr. Watson appeared for hearing. Based on your failure to appear, the court lifted the stay and entered a default judgment showing that $5,387.35 was owing to the plaintiff, and that amount needed to be paid or the property vacated by January 16th. Court staff mailed it to you at the address we have on record on January 5th, 2023.
Okay.
The plaintiff's office submitted it. I'm sorry, go ahead.
I didn't get that. Theodore must have, but.
Ma'am, when did he vacate the property?
Last month.
Ma'am, at issue here is that the judgment entered on January 5th. The application for an order of eviction indicates that no money has been received.
Okay,
Have you made payment on the judgment in this matter?
I have not, no.
Mr. Morton?
Your Honor, I can advise the court, I mean, was it that we appeared at court, default judgment was entered, this was after the Sierra stay was put in place, as this was back underneath a Sierra stay process. So at that point, was it payment was it the payment was not received since the default judgment was entered? And then the court sent out the default judgment. And then at that point, Your Honor, now we're here today. We filed the motion. We sent the motion out. The motion was served out to the party. The balance due and owing as of today's date is $8,982.25. There's been no payment made on this account. The last payment that was received was actually NSF. So the last payment that cleared was back in July of 2022. I know that often with some of my clients, you know, they still are, you know, confused with some of the Sierra things, and I thought they believe that this was still in a Sierra stay, and they'd had some communication with, I believe, Mr. Was it Watson? But at this moment, Your Honor, payment's not been received. This case was filed, I believe, back in August of 2022. So it's been going on for quite a significant time period. No payments been made. It's appropriate for the order of eviction to enter.
Anything else, Ms. Ziegler?
No, ma'am.
This case was filed on September 13, 2022. The court has recited the balance of the procedural life of this file. Inasmuch as plaintiff's application indicates that $0 have been paid towards the January 5th, 2023 judgment, and that remains true as of today, the court will grant the plaintiff's request for entry of an order of eviction. The court has signed that order, and it will be downstairs for processing momentarily. Anything else in that matter, Mr. Morton?
No, Your Honor.
Anything else, Ms. Ziegler?
How long do I have to get out?
Immediately, ma'am. The court officer, the file will be downstairs for the court officer to pick up the copy of the order of eviction.
Okay,
Thank you.
thanks.
Mr. Morton, is Ms. Burgess your witness?
That is correct, Your Honor.
Would it be beneficial for you to be in a room with she and Mr. Martin to go over the ledger, or do you need to just have Ms. Burgess alone?
I'd like to just speak with Ms. Burgess briefly, as it's been an active morning on our docket. And then I'll talk to her about bringing Mr. Martin in at that point. Since I have the ability to move people around, I'll go ahead and do that, Your Honor. Thank you.
Ms. Burgess, please go into the meeting room. I'm sending an invitation to you right now. Mr. Robinson, does your return mean that you're ready?
I'm ready, Judge.
Ms. Fryulich?
Ready, Your Honor.
This is 23017 LT. This is Sunbeam Property versus Oakley and Robinson Law Firm. May I have your appearances, please?
Good morning, Your Honor. Attorney Kiana Frank, P73015, on behalf of Sunbeam Property Management.
Good morning, Your Honor. Steve Robinson appearing on behalf of defendant.
This is the case that just keeps on giving. We were here and it was nope, I won't start like that. This case has been adjourned a few times now. Is there any resolution of this matter or are the parties in need of a hearing?
There is no resolution in this matter at this time, Your Honor.
I concur, Judge. I think we need to have a hearing.
Are you ready for a hearing this morning?
Well, my client was on standby at 10 a.m. It's 10:41. So, and this isn't for, I don't believe we filed for a money judgment. I think we only filed for possession, for failure to pay. But I will text property manager to jump on.
Well, I guess let's back up. Ma'am, how much rent is claimed as due and owing in this matter?
Your Honor, there's about $9,000 in rent due.
You said $9,000?
Yes.
Mr. Robinson, do you dispute that amount?
Your Honor, I do.
Your Honor, even if he disputes that amount, rent still hasn't been paid for April, May, or for May, April, or March.
March, April, and May.
And even prior to that, I'm just going for the most prior 3 months.
Well, I'm always shocked when two attorneys can't come at least close in a number. And I understand we were scheduled at 10 o'clock, but I don't know if any court is usually ready to call a 10 o'clock case at 10:05. So if your witness is on standby and you want to get them on, I am happy to call the case. There's only one other disputed matter this morning. If now is not a good time, we can talk about another time.
Your
What's
Honor,
your
we
pleasure,
had
ma'am?
come to an agreement on a dollar amount, but that was also, I believe, before the matter was set over again into May, and May hadn't been, I had sent a conditional dismissal. We didn't get a signature on the conditional dismissal. There was an agreed upon move out date. There was no move out date. I know that Mr. Robinson has continued or did have continued discussion with the actual owner in this matter and trying to resolve something even outside of court, but there has been extensive, I've prepared, and there has been attempts to resolve with conditional dismissals.
I know, and this is the thing. My notes are that on April 5th, you were both here. There was a conditional dismissal. There was an amount of rent due and payable. There was a vacate date, and based on that, the court adjourned the trial to the 19th of April. April 19th, I came and I logged on because we didn't have the conditional dismissal. Mr. Robinson was here. You were not. So I adjourned the matter again to today because I don't understand. Well, I do understand. But because you weren't here, I wasn't going to dismiss the case for your failure to appear because it was my understanding that you all were still having some conversation, but we are here this morning. So if you can get your witness on, you tell me how long you need to get them on. If that's not real, and Mr. Robinson, same for you. If you have the necessary documents and witnesses, I will call the case as soon as I get done with Mr. Martin, whose case was actually at 9 o'clock. So you tell me how we're proceeding.
I believe my witness can log in a few minutes. I'm just waiting on her. I'm sending her the Zoom info, etc.
Mr. Robinson.
That's fine, Judge. Of
Okay.
course, I do have it. I do have a probate matter too, but that was
What
scheduled.
time is your probate matter?
My probate matter was scheduled for 10:15, but Westland screwed me up with, because that was scheduled for 9:15, so.
Is your probate matter by Zoom?
It is.
Okay. I'm holding the file here. If you need to go to probate, that's a higher court and we'll wait. I'm here waiting. Ms. Fryluck will get her client on.
Very good.
I'm waiting for this 9 o'clock matter to resolve itself.
Thank you, Judge.
Thank you. Mr. Martin, I am stepping off for a second, but I'm not leaving. You're fine to stay where you are. I will be right back.
Okay.
Mr. Martin, I'm going to move you into one of the rooms and I'm going to talk to you. So we'll both be in there together.
Okay.
So when you see that prompt, please accept that.
Will it show up on the screen?
Yes.
Okay.
Okay.
What's the problem? What's the point?
It's okay. We're going to wait for the judge to come back out because they must have closed all the breakout rooms.
Sorry, my man. Mm.
Are we ready to proceed in the Harbor Club versus Martin matter?
Yes, Your Honor, the parties spoke and were unable to come to a resolution.
This is a recall of 231712 LT. This is Harbor Club versus Scott Martin. I already have your appearances in the file. Mr. Morton, is there an opening statement that you wish to make, sir?
Your Honor, we will present, testimony through through a company representative that the balance due and owing, is $500, which does include, fees, but also includes an unpaid balance that is accrued, as well as court costs of $167, which totals $667. And then finally, we also proof that there's been waivers of 2 amounts on the ledger to provide Mr. Martin some credit. And we will be seeking a judgment at that time.
Thank you. Mr. Martin, is there any opening statement you'd like to make, sir?
I ask for it all to be dismissed.
Thank you. Ms. Reese, what are you here for, ma'am?
I am here for 36830 Goddard.
Ma'am, I don't know what that is. What time was it scheduled?
Give me 1 second.
I'm sorry, are you here on the Sunbeam property matter?
Yes, ma'am.
Thank you. I'm having another hearing right now, but if you sit tight, the attorneys have both been here. Mute yourself and I'll call the case after this hearing concludes.
Absolutely.
Thank you. Mr. Morton, your first witness, please, sir.
Your Honor, I would call Miss Lindsay Burgess.
Hi.
Ms. Burgess, is your video available?
Yes, hold on.
Raise your right hand for me, please, ma'am. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Your witness, sir.
Your Honor, do I have permission to share my screen? Because I can present the
Yes, sir.
leads and ledger. Thank you. First thing, and I apologize, I'm not trying to get anybody motion sickness. Ms. Burgess, I'm showing you, do you see on your screen the first page of a document?
Yes.
Okay. And actually, before I go into that, you are Miss Lindsay Burgess, is that correct?
Correct.
And where are you currently employed?
The Waverly on the Lake.
And was it in that employment? What is your job position?
Assistant community manager.
And does your job involve was it processing of payments, reviewing of ledgers, and communication with tenants regarding past due balances? Yes. And you are familiar with the books and records as it pertains to Mr. Scott Martin, who resides at 49061 South I-94 Service Drive, but it's Unit 205 at the Waverly. Is that correct?
Correct.
And the Waverly, their formal name in matters is G&IX Harbor Club Property LLC, correct?
Yes.
Thank you. Again, on the screen, there is a document. Do you recognize that document?
Yes, it's his lease.
Okay. And so I'm going to show you. So the first page designates Mr. Martin, as the leaseholder, correct?
Correct.
Okay. I'm going to move down so I can just show the signature. So I apologize. Here we go. Do you have electronic signatures that regularly get executed on your lease agreements?
Yes.
Okay. And does this show, was it an electronic signature on the lease agreement?
Yes.
Okay. I'm scrolling back up to be able to reference, does it state does the lease agreement provide for what the ongoing, rental rates are?
Yes.
And what is listed as the base ongoing rental rate?
$932.
And then is there also an additional reoccurring utility charge?
Yes.
Okay, I'm going to scroll down to that. Again, I apologize in regards to the scrolling. So do you see this page marked as utility service addendums?
Yes.
Okay. I'm going to scroll down to the second portion of this page. Is there a flat rate that is charged for the utilities?
Yeah, 2-bedroom is 75.
Okay. And is that what Mr. Martin is charged?
Correct.
Thank you. Also, I'm going to scroll back up one more time. I do apologize. Was it in rents and charges? Is there an established amount that gets charged for late fees or charges if the balance is not paid in full?
Yes, $100 after the second.
Okay.
Second at midnight.
Thank you. And was it this document is a document that's kept in the regularly conducted business of the community? Is that correct?
Correct.
And was it and you recognize it as the lease agreement with Mr. Martin, correct?
Yes.
You're at this time, we'd move for entry of the lease agreement of Mr. Scott Martin with the community.
Mr. Martin, do you have any objection to the court receiving the lease?
No. I don't
Lease is
understand where
received.
he's going with this. What does this have to do with anything that we're talking about?
Your Honor, if I don't want to interrupt my continued.
So we're just establishing my rent's 1,007, right? And the agreement is anything past the second's a late fee? Is that what you're trying to?
Yes, sir.
Well,
Mr.
well, I knew
Martin,
that
what'll
for
happen
5
is,
years.
hold on. You will have an opportunity to testify and you will have an opportunity to question Ms. Burgess, cross-examine her. So let's let Mr. Morton proceed in his direct examination.
You can. I'm just trying to understand it. That's all.
Ms. Burgess, now I'm going to put on the screen, was it a new document? Do you recognize this document?
Yeah, the ledger.
And who is this ledger for?
Scott Martin.
And I'm going to, we'll see the first page. Does it designate his name on this ledger?
Yes.
Does it designate, was it his current, his address as well as the status of his account?
Yes.
Okay. And does this document, was it reflect payments that have been made as well as charges that have been placed on Mr. Martin's account?
Yes.
Okay. Is this document kept in the regularly conducted business of the Waverly?
Yes.
And I'm going to, so this is the first page?
Mm-hmm.
This is the second page, which was it most of 2020?
Mm-hmm.
Ma'am, no, it's not, it's yes or no, please.
Yes.
Thank you.
I think so.
Next page, do you see the third page of the document?
Yes, I do.
Okay. Lindsay, if you need to tell someone to go away, please do that, because we need to focus.
Yeah, I'm sorry. I have glass doors and people just have no boundaries. Sorry about that.
Okay. And then I'm going to show you the final page. This is the ledger for Mr. Martin, correct?
Correct.
From the document and.
Oh, nope, sorry. Oh, I knew that would happen. Sorry. That was my mistake, my apologies. So let's return to the ledger.
No problem. Okay. And then I'm gonna blow it up a little bit more. Okay. Ms. Burgess, do you see this last page of the ledger?
Yes.
Okay, I think where I was at was it, do the charges and entries that are on this ledger, do they accurately represent the records that have been kept at the Waverly?
Yes.
Okay. And this was a document that you provided to my office to show the balance that was due and owing, correct?
Correct.
And it is the regular conducted business of the community to be able to use this ledger to account for the amounts that have come due, as well as the charges and the payments that are made by Mr. Martin. Is that correct?
Correct.
Okay. I'm showing you, if you look at the total balance due and owing, what is listed as the total balance due and owing as of today's date?
667.
Okay. And that is inclusive of court cost as well, which was charged on, was it March 21st, 2023? Is that correct?
Correct.
Okay. I'm going to scroll back slightly. What was the last point on this ledger that Mr. Martin had a zero balance?
Let me see. August of 2022.
Okay.
I do believe, yes.
And was it since that point, there have been 2 points in which you have provided credits on this account, is that correct?
Correct.
It's one of those, was it from March 2023?
Yep.
And what
Yes.
was that credit for?
One was for $100 for a late fee and the other was $75 for a lease violation fee.
Okay. And those credits have been put on the account?
Yes.
Okay. And the charges placed on the account correlate directly with the lease agreement and the charges that you have the right to be able to put on the account, correct?
Yes.
Okay. And as of today's date, you're asking for a judgment in total of $667. Is that correct?
Correct.
Okay. I'm also gonna, make a reference to the fact that, has Mr. Martin had any recent work orders placed?
I can tell you, I logged out when you asked me that earlier. Hold on one second. He did.
And what were those work orders for?
He, on 3/15, he placed one and we completed it on the 22nd. He wanted his bathroom toilet replaced, a drawer replaced, and like another drawer. I think it might have been 2 drawers. But we did complete all that and we replaced his bathroom toilet, replaced the kitchen drawer, and then replaced a bathroom drawer.
So you were responsive to requests for condition issues that needed to be replaced, correct?
Correct.
Okay. And again, at this time, you're asking for a possession judgment totaling $667.
Correct.
Okay. No further questions, Your Honor. Actually, I take that back. I would move for entry of the ledger as a business record.
Mr. Martin, do you have any objection to the court receiving the ledger?
Ledger stating that this means this is it, the layout or something.
Yes, sir.
I don't have any copy of that and I'd like to go over that. This is just now being shown to me for the first time. I don't know how accurate this is. Just because it's said or she says that doesn't mean it's always true. And
Scott, you came in here. And
hang on.
No, ma'am.
My turn. Now, what you're talking about, the work orders, that is absolutely wrong. Okay,
Mr. Martin.
Yeah.
Mr. Martin, listen, here's the thing.
What is?
If you all could talk to each other and resolve it, you would have, and you have not. My question to you was a simple question.
What's
Do you
that?
object to the court hold on. Do you object to the court receiving the ledger? And your response to me was you had not
Yes.
had the opportunity to review it, which means
Okay.
there's an objection. So
Yes,
the question
that's
is,
an
how do we get a copy of the ledger to you so that we may have a
Ma'am.
reasonable discussion about what's in there?
Well, you can give it to me. You give a copy and give it to me. I can go to the office or whatever you need. I don't care. I just need to go over that because I can see by looking at it, there's manipulation there. The big manipulation comes from the work orders. I've been asking for years for a carpet since I
Mr. Martin.
started.
Mr. Martin, did you bring documents with you today to show when payments were being
No,
made?
because there was an app that they took me off of and I can't even get on the app now. They took me off the app when they gave me the eviction notice. So I didn't even have a chance to go over any of this because they took me off the app. And then I tried going to the office.
Well, let's,
to resolve this,
Mr. Martin, here's the thing. When I start talking, you stop talking. not disrespectful. It's just, we want us, I want us to move in the right direction.
I do
So
too.
when you came out, hold on, when you came out of the breakout room, my question was, are the parties ready to proceed? And there was a disagreement. So I asked Mr. Morton to put the amount of rent owing on the record. He did that. You said you disagreed. And I said, based on the disagreement, do the parties want to have a hearing? We can do it this morning if you have your witnesses and documents available.
The
Mr. Morton
rent's
said he would
right.
get his witnesses on. He would get his witness on, and you said you were ready. But now you're saying you want an opportunity to review the ledger.
Yeah, because you're just throwing this all up at me right now. I've never seen any of that. I didn't see it until you just showed it to me right there. So when would I ever have a chance to go over that? And how do I know it's all accurate? She could have made up anything she wanted, just like on the work order. She can make up that whenever she wanted to. And I noticed what's not in there is what's not in there is my work order about the carpet for 5 years that I've asked every single year that I not got. What also isn't there.
Your Honor, I'm going to object at this point if the court wants to.
What
make a
also is
determination, don't
not there is a work order for a washer and dryer that I went out for 3 months. That's not stated on there also.
This is a non-payment of rent case. Full stop and period.
But I-
Mr. Morton is
my
alleging,
rent's
hold
paid.
on, no. Mr. Morton is alleging that rent has not been paid and there is amount due of $500. When you came out of the breakout room, the issue that was raised was asked to the late fees. Mr. Martin has a
Right.
legitimate question about being able to review the documents that are presented in this matter. So I don't want to do this, but with Mr. Morton, what I'm inclined to do is to, if you want to finish your examination of Ms. Burgess, we need to get a copy of the documents that you're presenting to the court to Mr. Martin so that he may review them. And I don't know what review looks like if you.
Your Honor, I can send him a copy immediately. Was it by email? I can, however the court would prefer. Was it, and I also know that the courts, has its schedule that it must follow. So if the court feels like it's necessary to have a short adjournment on this matter, I understand the court's determination on that. As the court stated, I advise Mr. Martin of this, the court may set this for a separate hearing date. It may move forward today. It just depends on how the parties was communicating how the matter handles.
We're not going to move forward today because Mr. Martin should be allowed the opportunity to review the documents. Mr. Morton, what we will do is Mr. Morton, I will guess it's just the lease and the ledger that your client will be testifying regarding, correct?
That is correct, Your Honor. I mean, depending on where things go, I might have them, and there might be some rebuttal documents depending on how the matters proceed when it comes to condition issues and things like that. But right now, my only intent is to provide the lease and the ledger, as this is a non-payment of rent case.
Mr. Morton and Mr. Martin, are you both available next week, the 24th?
Yes. Oh, hang on. What's the day is that?
Wednesday, the 24th, sir.
Wednesday? Yes.
Okay.
Yes, I'm available.
But I'm sorry, Mr. Morton's checking the schedule.
Yeah, no, Your Honor. Actually, I think right now what I have on my calendar is other hearings with you in the morning right now.
What we will do is, let's say the 24th at 11. I already know that I have an 11:30. We will do it as a Zoom. If you want to finish your examination of Ms. Burgess and have her rejoin us next week and start with the cross, or if you want to stop right where we are.
I think it would be best to stop right where we are, Your Honor. I would just ask Mr. Martin if he could provide an email address, and I can certainly email these documents to him today.
We're going to do one better. Mr. Morton, there is an email address in a chat to you. Send those documents right here, right now. Mr. Martin, step out in the hallway. Somebody will bring those documents to you momentarily. We will adjourn this matter. We will resume on Zoom on next Wednesday, May 24th at 11 a.m. That's the only thing scheduled at 11. There's a trial that starts at 11:30, but I will take you up at 11.
Okay.
I'm putting these documents into an email as we're talking, Your Honor. So I will just log out and then email these documents to you right now.
Thank you. And then, Mr. Martin, as soon as the documents are received, they will be printed out and an officer will bring them to you.
Okay,
Thank you, sir.
thank you.
Thank you, Your Honor.
You can go right out that door to your left. That concludes this matter. I will see you next week.
Okay, thank you.
Thank you.
And I believe that's the last matter in front of the court with my matters, Your Honor.
Do I close
It is,
this
Mr.
out?
Morton. Have a good day.
Thank
No,
you.
sir, leave it like that. The staff will come
Oh,
and reset it for
okay.
the next person.
All right.
Thank you. It's the case that keeps on giving. Your client is here, ma'am. I put her in a miscellaneous room. I have no secretary. The day started off bad and it's just been a roller coaster. Do you need to speak to Ms. Reese?
No, me and Ms. Reese have communicated, Your Honor, thank you, but I agree with the day. I'm actually sitting in my car in front of East Point District Court because I was here much longer than I needed to be, and I had several Zooms, and I got at the hospital late, so it's just like the day that, like you said, the morning and day that just keeps on giving.
I come in, I'm all happy and full of vigor. I have everything labeled. I have everybody with their special breakout rooms. And then when it goes off the rails, and I know Mr. Robinson had a probate thing, but I'm leaving us up. I'm leaving us streaming. Hopefully he'll pop back here momentarily so we can get the case call. He's not even here in the session.
No.
And I
I've
know,
been
I'm sure you
coming
have
in and
things.
out, just waiting, but this. And Your Honor, just for the
know.
record, the last hearing, just as I was logging in, my paralegal called me and said that they adjourned it, like for the last hearing, but there's not necessarily a discrepancy on the dollar amount. It's possession. Like, you ain't paying
listen,
rent, man.
What I'm waiting for just came through. Sit tight. I'll be gone for less than 2 minutes. If I can find my keys.
I'm not going anywhere. I'm parked.
Yes, ma'am.
Your Honor, how much longer are we gonna wait on Mr. Robinson? Because I have other hearings too, but I'm still here. I kept coming back
I
and
know.
forth.
I'm looking at 11:30 and I hate to say that to you and to Ms. Reese, but if he's not here at 11:30, I will entertain your motion.
Thank you, Your Honor. just a sunny day to be sitting outside in the car. I'm sorry. I can't help it. I honestly, I whistle that spontaneously out of nowhere all the time. My husband finds it to be the weirdest thing. Well, one of the weirdest things about me. But I just whistle it. I have no idea why.
Well, since that show still comes on television from time to time.
It does.
Oh, yeah.
Like on regular TV, not like TV Land or Turner Movie Classics or something.
I don't know what station it is, but I know that it comes on because I hear the music and I always laugh that it still is a good and interesting show after all these years.
Wow.
Yep, this is 230179 LT. This is Sunbeam Property versus Oakley and Robinson Law Firm. This case was scheduled at 10 o'clock. The parties had been here. It is, I didn't keep track of the exact time, ma'am, but about 11 o'clock, I indicated that I would call the case after I concluded another landlord-tenant matter. Mr. Robinson had been here, had been in Westland, indicated that he had a probate matter that was by Zoom, and the court's anticipation was that he would stay muted on this court session and log on to the other matter and return. It's now 11:30. He has not returned. How would you like to proceed this morning?
Your Honor, at this time, I would move motion to court for a default judgment in this matter. And as the court has already recited on the record, I would just clarify a little additional. I believe it was about 10:45 when Mr. Robinson stepped away, because that is approximately the time that my witness was appearing, and I also went in and out checking on another courtroom. We have been back and forth several times on this matter. I have sent more than one conditional dismissal to Mr. Robinson in an attempt to resolve this matter. In good faith, I will stick with the original agreed amount for the default of 8,500 that was in our original conditional dismissal. That does not take into consideration additional fines, costs, or fees. If needed, plaintiff will seek it in a separate civil suit. But at this time, we are seeking possession. He's been in the property for too long without payment.
Did I hear you say 8,500? I thought the rent was 9,000.
The total amount that was originally due at that time was 9,000, but in our conditional dismissal, we had agreed to reduce down off the fees that were due at the original time in April, and we went down to 8,500. So we're not even including May's rent in this dollar amount. So we're reducing it down.
So, okay. It is May 17th. The case has been called. Mr. Robinson's not present. What is it that you want in your default judgment?
Your Honor, a judgment of $8,500 in possession within 10 days.
If you email it over to the court civil department, they'll process it, send it up here for signature. I anticipate a motion from Mr. Robinson. I'm sure you do as well.
I do as well.
Anything else this morning?
Nothing further, Your Honor. Thank you very much.
Thank you, ma'am. Go whistle your song somewhere else. Have a good day.
Thank you. You too. You can log out, Ms. Reese.
That concludes this matter. This court stands adjourned.